ability to do its work. He says staff at Gupta Link Trillion will try and avoid accounting to the inquiry's chief investigator, Terence Nombembe. Khaya Sithole joins us now. Thanks so much for that. Appreciate it. So you believe the state capture inquiry may already be discredited. Explain why.
So one of the big problems that we have with the state capture inquiry is that the chief investigator is a guy called Terence Nombembe, who in his previous life was not only the Auditor General, but also served as the Chief Executive Officer of SAICA. And in his capacity, the Chief Executive Officer of SAICA actually accepted a donation from a Gupta Link company, which was Trillion Capital. And of course, what then happened is that once the issue came into the public that SAICA had received the money from Trillion Capital, they were forced to pay it back. But in the process of them paying the money back, he, in his capacity, the CEO of SAICA, then said that the reason we paid the money back is because we identified that Trillion was a tainted entity. So, of course, if a person is going to come out and already say to the public that Trillion is a tainted entity, it then gives the impression that he's already prejudged the Gupta-linked entities on the basis that they're guilty of something. So, of course, what that then means is that the people that are essentially linked to Trillion Capital, who might have to testify in the State Capture Commission, especially when you get to the Trillion conversations around their contracts with regiments and all these other state-owned enterprises, there is a legitimate expectation that those individuals will say, look, the lead investigator has already made pronouncements that are adverse against the company that we represent, so we do not feel that it's being objective in an assessment. And of course, if it's not being objective, it means that the entire process is already compromised. So it's something that I think Justice Zondo should apply his mind to say what will happen if people simply say that we cannot present ourselves in front of this man because he's already been part of a long-standing conversation relating to our entities.
But the Deputy Chief Justice of the Constitutional Court, by the way, is a man of good standing, and he gets everything that happens legally in South Africa. So he, of course, the EFF came forward and said that we don't want Nombembe because it would discredit the Commission of Inquiry. He rubbished that and said, no, you can go ahead. So he obviously would have thought about the consequences of having him on the team. Yeah,
of course, but the problem is that he did not engage with these individuals who think that that is still a legitimate reason not to appear before the Commission. So, of course, if people are going to simply say that there's a legitimate reason for us not to appear before the Commission, it simply drags out the Commission. It might turn out that the Deputy Chief Justice is correct in saying that they don't have a leg to stand on, but for them, that is not the point. The point is, for as long as they can propose this as a possible avenue for them saying that we do not want to appear before the Commission, it will then have to be ventilated in an alternative dispute resolution platform where, of course, the DCJ will have to say, this is my view, and then they're going to have to express why they feel uncomfortable. And, of course, somebody's going to then have to adjudicate and say, actually, even though Terence Nombembe has been part of SAICA before, which has been on the Gupta payroll, we still feel that he is not discredited as a lead investigator. So all it does is simply adds into the timelines. I do not think that the individuals that are dealing with here are individuals that are persuaded by what you and I might regard as common sense or reason, or what the DCJ might regard as common sense or reason. For them, it's a matter of how far can we defer this particular process until literally it takes years for us to get to the final conclusions.
Now, to come clean, of course, there's some beef between you and Terence Nombembe because he actually accused you of leaking that information to the EFF. SAICA has a case against you about irregularities while managing a trust, a university trust fund as well. So people will question that naturally.
So of course, for me, one of the reasons that I highlighted even in that case, I said it was quite strange that that case only really became a thing once I had approached SAICA and Nombembe himself and said, look, I have information that indicates that you guys have received money from the Guptas. I do think that you need to come out clean and say to the public that, yes, we did receive the money. And for me, it was a matter of why were they not willing to disclose this information publicly? And of course, it was only after I intervened that they then said, okay, we're going to tell the public. But of course, what then happened thereafter is that Julius Malema and the EFF got hold of that information, and they seem to have formed the opinion that I must have fed that information to the EFF. So then, of course, then they came up with these trumped-up charges, which even now they still haven't been able to prove against me. So I think it is a very interesting sort of intersection. But also, quite importantly, as I was watching Mr. Jonas's testimony today, what was quite fascinating is that as soon as the whole Mr. Jonas situation materialized around March 2016, and Thuli Madonsela actually released released her report, I then went personally to Saxon World to interview Ajay Gupta. And one of the questions that I asked him is to say, look, Mcebisi Jonas said you offered him 600 million rand. Is this accurate? And of course, Ajay Gupta then said to me, look, I've never met the man in the first place. So then I turned around and said, look, this man said in March 2016 that you offered him this particular bribe. You are telling me now in November 2016 that you never met him before. How does this happen? And Ajay's view is that, look, it's a big compound. Saxon Hall is a big compound. I was in there and he showed me that it is a big compound. And his argument was that, look, it is possible that Mcebisi Jonas could have been at Saxon Hall, but if he was at Saxon Hall, it wasn't there to meet Ajay Gupta. So then I said to him, look, since March 2016, it's now November, surely you could have asked around in this compound to say, guys, has Mcebisi been here and who did he meet? And of course, he couldn't give me a credible reason why he hadn't asked around in his own family to say, this man says he met me, I've never met him, who exactly did he meet here if he did come to this particular compound? So I think on that basis, there's clearly a dispute of facts relating to what really happened at the Saxon Hall compound when Mcebisi Jonas was there.
Many things are going to be disputed, Khaya, and I want to go back to the SAICA claim against you because you've told us the allegations against SAICA. So let's talk about the alleged irregularities on your part that they are claiming happened. 129 students apparently pushed through, costing them an additional 10 million rand. What exactly happened there?
Yeah, so what tends to happen is that, you know, what SAICA does is that it appoints agents at various universities. And essentially what they say is that please go and represent our interests there. And our interest is that we want to run a bursary program at an institution. So we give you the powers to essentially identify the students that should be on the program. And of course, once you identify the students, do whatever is necessary to get them into a program. So I actually did this for about a 6-year period. So I did it firstly at the University of KwaZulu-Natal and then at the University of Witwatersrand. And then somewhere along the line in the 6th year, they then turn around and say, oh, the basis of you enrolling the students on the mandate that we've given you is something that we regard as fraudulent. So then the question was, well, if you regarded this thing as fraudulent, why did you pay for these students for a 6-year period if you are now saying that I never had the mandate to enroll the students? So of course, their case is really quite nonsensical in anyone's view, because then the question would be, well, if you're saying that this conduct was fraudulent, why did you make payments for 6 years and 12 semesters across 2 different universities if you're now saying that this man never had the mandate to act on your behalf? So that is really the crux of the case. But the reality is that the reason they brought up the case was not because this case was something that really offended them. The case, according to them, happened in 2016, and they only bring up the charges in 2018. So the question that we asked is, why did you wait for so long if you feel so aggrieved by what you regard as a fraud? And then they said they were too busy to pursue the case. So of course, one can see that they're talking absolute rubbish. And the question here is that they were really trying to silence me on the basis that they thought I was going to get to the AGM and ask for the board to be disbanded. But it turns out I didn't need to go to the AGM because the board has been disbanded on the basis of the issues that I raised.
All right, clearly you guys have issues. I hope you sort it out. Thanks so much for your time. Appreciate it. That was